once again, I rise and wish to lend my support to the honorable mover of the bill shortly entitled the Constitution of St. Christopher Nevis, Tenure of Office of Prime Minister Amendment Bill. Madam Deputy Speaker, the purpose of this bill is to amend the Constitution of St. Christopher Nevis, and particularly to limit the period that an elected representative could serve as Prime Minister of the Federation. That limit, we say, will be no more than 2 terms. That is what the bill is. So that if you are elected to the House of Representatives, National Assembly, the Parliament, and you command the support of the majority of elected representatives, the Governor General can appoint you to Prime Minister. Then, if you do so again a second time, he can appoint you to Prime Minister. But the import of this bill is that it limits such a representative to 2 terms and 2 terms alone. I want to say at the outset and emphasize that this bill is not retroactive. It's prescriptive. It means that it only works going forward. It has nothing to do with what has happened in the past. So that, for instance, our first Prime Minister, national hero, the Right Honorable Sir Kennedy Alphonse Simmons, if he was to consider and run for elections again and to be successful and come to the House and had the support of the majority of people in the House, representatives, he could continue to be Prime Minister, even though he has served 4 terms before in this national parliament. And I dare say the same will also be for the member for number 6, who has also served 4 terms in the past. This bill is intended to restrict any representative who becomes Prime Minister going into the future to 2 terms and 2 terms alone. That's what this bill is about. And it's very important to make that point at the onset. And I'll come back to it. Madam Deputy Speaker, during the course of our parliamentary history, there have been a number of very colorful and memorable moments. I believe that this particular amendment that is before this Honorable House today is the first of its kind in St. Kitts and Nevis. This bill, if it is successful, would have the singular distinction of being the first direct amendment to the Constitution of St. Christopher Nevis. And I need maybe to spend a little time talking about that. The Constitution of Federation of St. Kitts and Nevis is like other constitutions that sets rules by which the country functions. It sets up the framework of the country. And it's the most important document in our country. The Constitution of St. Christopher and Nevis starts with a preamble. That's an introductory section that allows us to establish that we believe in Almighty God and the inherent dignity of each individual. That we believe and assert that the people of St. Kitts and Nevis are entitled to the protection of fundamental rights and freedoms. That we believe in the concept of true democracy with free and fair elections. That we desire the creation of a climate of economic well-being in the context of respect of law and order, and are committed to achieve our national objectives with a unity of purpose. That's the preamble to the Constitution. And it goes on to be set up and divided into various chapters. It is set up and has sections to those chapters. So that, for instance, there'd be some 11 chapters to the Constitution and dealing with a whole range of stuff, such as it grants the protection of fundamental rights and freedoms. The executive sets up a governor general, parliament, the executive finance, the public service, and so forth. It speaks about citizenship, judicial provisions, and the island of Nevis. Madam Deputy Speaker, perhaps the most important, one of the most important sections of the Constitution, and there are some 120 sections in this Constitution, in those 11 chapters. Section 2 says, the Constitution is the supreme law of St. Christopher and Nevis, and subject to the provisions of this Constitution, if any other law that is passed by this Parliament is inconsistent with this Constitution shall prevail, and the other law shall, to the extent of this inconsistency, be void. So the Constitution is the supreme law, and everything must conform to it. This bill we then pass amends the Constitution to become part of the Constitution and is the supreme law. It's important to note that. Madam Deputy Speaker, the rationale is to move forward and advance our democracy as a maturing federation. The bill therefore seeks to serve as a check to prevent the potential abuse of power by our leaders. Madam Deputy Speaker, under the current system of unlimited terms of office for the Prime Minister, we are more likely to run the risk of certain personalities becoming entrenched in their office, which may not necessarily augur well for the best interests of the state and the overall well-being of democracy here. The objective of this bill, then, is to reflect the term limit system, which has been well accepted and embraced by a number of democracies around the world. And I dare say, in our region, there are at least 2 that have done so in the English-speaking Caribbean. Whilst our current system is not undemocratic in and of itself, we are constantly seeking ways in which we can improve upon the manner in which the business of the state is arranged, and that would provide our citizenry with the greatest level of confidence. Madam Deputy Speaker, democracy is a curious creature. Leaning too far in one direction or the next may wind up facilitating certain undesirable outcomes. In other words, limiting the term of office of our prime ministers seems to be a good ingredient for enhancing the pattern of our democratic construct. Madam Deputy Speaker, the bill, whilst it may appear straightforward in its composition, it is nonetheless quite weighty in its import to our constitutional system, and it seeks to promote a healthy democracy. We believe that the introduction of measures for greater restraint on the exercise of political power is a constraint in favor of democracy. And in that regard, Madam Deputy Speaker, whilst the bill as constituted may represent a paradigm shift in our traditional approach to governance in the Federation, we nevertheless believe that it's a necessary advancement that is timely, but also represents an important next step in our maturation as a sovereign state. Madam Deputy Speaker, some people may feel that a popular prime minister should serve as long as the people are willing to continue to vote for him. History has, however, shown that term limits strengthen democracy and in the long term promote peaceful political traditions. Madam Deputy Speaker, the long title and preamble of the bill provides that it is a bill to amend the Constitution of St. Christopher Nevis to limit the term of office of the Prime Minister and for related matters. And in its preamble, it states that whereas the Constitution of St. Christopher Nevis is set out as Schedule 1 to the Constitutional Order of 1983, and whereas under Section 52 of the Constitution, there shall be a Prime Minister who shall be the representative who appears to command the support of the majority of the representatives and who shall be appointed by the Governor General. And whereas, pursuant to Section 38(2) of the Constitution, a bill to alter Section 52 of the Constitution shall not be regarded as being passed by the National Assembly unless, on its final reading, the bill is supported by the votes of not less than 2/3 of the representatives. And Madam Deputy Speaker, I should maybe explain that a bit. What we say is that in chapter 4 of this Constitution, Chapter 4 of the Constitution, or that should be Chapter 5. Let me just be sure, Madam Deputy Speaker.
Executive and ministers and so on.
Yes, that should be Chapter 5. Should it be? Yes. Chapter 5 is headed the Executive. And it starts off at Section 52. Subsection 1 says, there shall be a Prime Minister of St. Christopher and Nevis who shall be appointed by the Governor General. And subsection 2 says, whenever the Governor General has occasion to appoint a Prime Minister, he shall appoint a representative who appears to him likely to command the support of the majority of representatives. This is Section 52 that the bill speaks of. And we are moving in Clause 3 of this bill to amend this particular section and subsection. the amendment of Section 52 of the Constitution. The Constitution is amended, so says our bill, in Section 52 by inserting new subsections 52(2)A and Section 52(2)B as follows. So whereas Section 52(2) says, whenever the Governor General has occasion to appoint a Prime Minister, he shall appoint a representative who appears to him likely to command the support of the majority of the representatives. We now say in 52(2)A, notwithstanding that subsection 52(2), a representative shall not hold office as Prime Minister for more than 2 terms, whether or not served consecutively. And therefore, if somebody wins an election as a representative and sits in the Parliament with other members, other representatives, if the Governor General believes that that individual commands the support of the majority of the elected representatives, then he'll appoint him as Prime Minister. But he can only serve 2 such terms. And this last part of that, the phrase that ends, whether or not served consecutively. So there could be this term and the next, or he may step down or lose an election, but can come back for another term after that. But he should not go on for a 3rd term. And I want to stress again, this is prescriptive, going forward, and has nothing to do with what has happened in the past. So it does not affect, like I mentioned, our first Prime Minister, who would have served 4 terms. He could come back and serve 2 more terms. It would not affect our second Prime Minister, who has served 4 terms. He could come back and serve 2 more terms. The bill is prescriptive and has nothing to do with what has happened in the past. And it's an important point to make. So that is what this does. And those 2 terms can be one after the other, consecutive, or there can be a break in between, and the person can come back for a 2nd term. But after that 2nd term, they can come again. So that's what this bill is saying. And there are reasons why we have said this. And we'll come to that later. In Section 52(B) to this same amendment, it's important to understand what we mean by a term. And it says, in this section, a term refers to the period provided for in Section 31 of the Constitution. And what does 31 say, Madam Deputy Speaker? Section 31(1) says that an elected or appointed member shall vacate his seat in the National Assembly at the next dissolution of Parliament after his election or appointment. So that a term has to be when Parliament begins and when it is next dissolved. That is a term. Parliament might go for 5 years, as is set out in the Constitution. But that term could be a 1 year, could be 2 years, could be 3 years. But the term is the beginning and the start of the Parliament, and the dissolution of the Parliament makes 1 term. And so the 2nd term would then be the start of the next Parliament and the dissolution again. So that is exactly what this bill is trying to do, to limit how that is. Again, Madam Deputy Speaker, you will recall that I earlier said that the Constitution is the supreme law. And once the Constitution allows or provides for the term limit for the office of Prime Minister, then this must be given effect. This particular amendment of the Constitution is an important matter that requires support by the votes of not less than 2/3 of all the representatives on the final reading of the bill. And I need to discuss that and explain that to this Honorable House, Madam Deputy Speaker, because that is in the preamble of this bill. And it states very simply in the preamble that whereas pursuant to Section 38, subsection 2 of the Constitution, a bill to alter Section 52 of the Constitution shall not be regarded as being passed by the National Assembly unless, on its final reading, the bill is supported by the votes of not less than 2/3 of all the representatives. Let me go very simply, Madam Deputy Speaker, to the Constitution, the supreme law. And it says here at section 27, that a person may be qualified to be elected or appointed as a member of the national, if and shall not be so unqualified unless he is the age of 21 or upwards and his parents are born and so forth. But it's important to understand what I am referring to. It says here section 29 is what I'm looking for, Madam Deputy Speaker. The election of representatives. Each of the constituencies established in accordance with the provisions of section 50 of this Constitution shall return one representative to the National Assembly who shall be directly elected in such manner as may, subject to the provisions of this Constitution, be prescribed or under any law enacted by Parliament. So this law really speaks to an elected person, somebody who runs for elections and is elected as a representative in this Parliament. Only elected members can be appointed as Prime Minister. It's important to understand that because in section 38(2) that this bill speaks to, it says that a bill to alter any of the provisions of this Constitution or the Supreme Court order shall not be regarded as being passed by the National Assembly unless on its final reading the bill is supported by the votes of less than 2/3 of all representatives. Representatives, as I've said, means elected members. There are, in addition to elected members or representatives in this Parliament, there are nominated members who are also appointed. And they are called senators instead of representatives. Senators, of the senators, 1/3 of their number, excluding any senator who holds the office of Attorney General, shall be appointed by the Governor General, acting in accordance with the advice of the Leader of the Opposition. The others shall be appointed by the Governor General, acting in accordance with the advice of the Prime Minister. These are nominated by the Leader of the Opposition or by the Prime Minister, and the Governor General shall appoint them as senators. This bill does not refer to them. And so in section 38, only those who have been elected to the National Assembly can vote. There are 11 members in this National Assembly because there are 11 constituencies who have been elected as the representatives. And 2/3 of those 11 have to vote for this bill. If you do our maths, we'll see that we're talking about 7 and what, 1/3? If you divide 7 and
0.33.
have done 1/3, 7.33. So you need 7 elected representatives and 1/3 of a representative to vote with you for it to pass. Is only 7 of them vote? It ain't enough. You need 1/3. Or at least one person who makes up 1/3. For this bill to pass muster in this House, we need 8 elected representatives. And that is something to consider. So this really is what the constitutional amendment is. And this is different, Madam Deputy Speaker, from bills that normally come to the Parliament. Because those bills normally only require a simple majority. So if you have on one side more than half of the number of members who are here, that bill will pass. But when it comes to the Constitution, it requires that special majority. You need 2/3 of the elected representatives in this bill. And I need to go on to explain how else we can change the Constitution, because it's important to note for a particular reason. In subsection 3 of section 38 of the Constitution, it says this, Madam Deputy Speaker: a bill to alter this section, Schedule 1 to this Constitution, or any other provisions of the Constitution certified in Part 1 of that schedule, or any of the provisions of the Supreme Court order specified in Part 2 of that schedule, shall not be submitted to the Governor General for his assent, unless A, there has been an interval of not less than 90 days between the introduction of the bill in the National Assembly, so that everybody could get to know about it, and the beginning of the proceedings in the Assembly on the second reading of the bill. And B, after it has been passed by the Assembly, the bill has been approved on a referendum by not less than 2/3 of all the votes validly cast on that referendum in the island of St. Christopher, and 2/3 of all the votes validly cast on the referendum in the island of Nevis. So there are some provisions of this Constitution that will require that a bill to amend the Constitution, that section of the Constitution, requires only 2/3 of the elected representatives. But there are a number of sections of the Constitution that, in addition to that, also require that it goes to the public, to the people, to cast and vote in a referendum. It's important to note, because this particular bill, this particular section of the Constitution does not require a referendum. There's nothing in it. And for that, we can turn to Schedule 1 of the Constitution that sets out which provisions of the Constitution require not just 2/3 of the elected members, but also require 2/3 of the voters in St. Kitts and 2/3 of the voters in Nevis. The whole of Chapter 1. And Chapter 1 in the Constitution, Madam Deputy Speaker, speaks about the Federation and the Constitution. And in Chapter 1, the most important part that I mentioned to you earlier is that the Constitution is the supreme law. If you want to change that, you need to have 2/3 of the members here in the Parliament, the elected representatives, and then we have to go outside and have a referendum where all the voters in St. Kitts, 2/3 of them, have to vote in favor, 2/3 of the voters in Nevis, or it don't pass. So that's Chapter 1. It also says Chapter 2 of the Constitution has to go through that process. And what does Chapter 2 talk about? Protection of fundamental rights and freedoms. all of those very important matters about the body politic, the person, human rights events that we have inherited from the United Nations and the various conventions around the world. In chapter 3, you talk about 3 sections that require both a 2/3 vote of elected representatives and a 2/3 vote of the referendum of our people as well in St. Kitts and in Nevis. And what are those sections? Sections 21 and 22 that deal with the Governor General. And here this one. It also goes to the executive, sections 51 and section 56. Section 52 does not fall in this. So there is no constitutional basis for us to require a referendum on section 52. Section 51 does, and section 56 does, but not section 52. So there's no need for a referendum. You need a 2/3 vote of the elected members of the National Assembly. And it goes on to specify the other sections of the Constitution that would require a referendum. This is not one. Madam Deputy Speaker, I want to, in fact, note that, again, that no ordinary bill is able to override the current constitutional arrangements that empower the Governor General to appoint the representative who appears to command the support of the majority of the representative. It's important to say that. Right now, the Governor General is tasked with appointing the Prime Minister, according to the Constitution. And no ordinary bill can change that. However, to advance this national aspiration to strengthen our democracy, the Constitution itself must be modified by the elected representatives of this House to do what we plan to do. And that's why we are here. It is the most important thing that we are doing since independence. Since 1983. This is the first time we are doing this. Historic, the first time that we have found that we should do this. And we're doing it for a reason. And I'll come to that. Madam Deputy Speaker, it was the first President of the United States of America. I heard the Honorable Mover, the member for number 6 earlier, speak about number 7, speak about the role of the United States where they have term limits, where the President just serves for 2 terms. But it was the first President of the United States of America, George Washington, who established this important precedent and stepped down after serving 2 terms in office, believing that this system of limited terms to be in the best interest of his nation. This selfless act of giving up his political power at a time when he was being pressed to serve another term, George Washington was recognized by Britain's King George III himself as the greatest man in the world at the time, having fought for and won the independence of the United States of America. And maybe we need to consider our own Prime Minister in that light, in that he is bringing this bill, moving a bill to limit his own power. This bill really should be called the Harris Bill. Because do you expect a man in power say, boy, I only want to serve 1 more term? Because that's in effect what he's doing. This term, if passed, and the next term, and after that, the member for number 7 can come back. It is the Harris Bill. This is about the current Prime Minister. This ain't about any other person. It's not about our first Prime Minister. It's not about our second Prime Minister. It's about our current Prime Minister, who is openly the open mind saying, what has happened recently to us? I don't want to find myself in that same position. And I want to limit what I do. Going forward, our country should not be subjected to that. And so, Madam Deputy Speaker, that is where we are. And I think it's perhaps important to understand why we are talking about this. It was the move of the bill, the member for number 7, who made a reference to our manifesto. Our manifesto promise, the manifesto of team unity. That was the manifesto headed, Manifesto 2015 to 2020. Prosperity for all, we said at the front. And he had already mentioned those promises that we had looked at. $500 for family support for those under 3,000. What a boon to our people. Huh? It was around this time last year that we introduced that. That was a promise made by this government. PEP upgraded to step up. No VAT on food, medicine, educational supplies, funeral expenses. Creation of 2,000 new jobs. Prompt payment of overdue $16 million gratuity. Construction of 2,000, and I could go on and on. Yeah. These were manifesto promises that have been delivered. But why did we do that? Why did we make those promises? And for that, we have to go back to what happened in 2012. Because that's when this journey of this Team Unity administration began. It began when, in September of 2012, there was a land for debt swap bill in this honorable house. Out of clear blue, land for debt swap. Huh? When we had some 1,200 acres of land in prime places where ordinary people live, in Sandy Point, in Old Road, Bochels, Lodge, just carry on, just go on, poof, and why they went poof? Lest we forget, this was to satisfy a debt that was incurred by a previous administration. Between the period 1995 and 2010, every single year, year after year after year, when we came to budget estimates, there was a deficit. The government was spending more than what we're taking in, and we are borrowing money.
At historic levels?
That was historic.
Yes.
Every year, except 2008 and 2009. Right. Every year, we got about 125 million in 1 year.
2008 and 2009?
Yes.
What Minister of Finance did?
When the Honorable Dr. Timothy Harris was the Minister of Finance.
So he made the difference.
The member for number 7. It's like he had it in him then. But this debt that was created, it started there. We remember that after the 2010 election, we went to the dreaded IMF. We went to put ourselves in the hand of the IMF. That's when we got VAT for the first time in this country.
Homegrown structural adjustment.
Homegrown structural adjustment, 17% thrown on people, food, everything. This haircut that we get, churches lose half of their value in treasury bills. Water gone up 600%, electricity up 86%. All of this was happening.
Increment stuff.
There was a moratorium on civil servants increment, 3 years. Can't get no increment, no more money. This is where this thing starts. There was horrors going on. Horrors. And don't forget, at the same time, we had this mismanagement of the CBI that led us to this dreaded Vincent. The U.S. Treasury Department put a warning on us, Vincent, that still we're fighting to get out of. And later that year, 2014, there was the withdrawal of visa-free entry into Canada. by the Canadian government. Mismanagement. There was this horrific period in our immediate history. And all of this, land for debt, when people in this country became mobilized, were disconcerted, took to the streets, 1 demonstration, 2 demonstrations here on the streets of Bastille, and ended up as it was. By the time we get to the 10th of December 2012, we hear a statement from the Minister of Finance, Prime Minister, that the budget debate, which was for the 11th of December 2012, should be postponed. No new date, but was postponed indefinitely. If I remember, it was maybe 4 months later it come. Eh? Huh? I don't know. Huh? But that was what it was. Huh? No budget on the 11th. And what happened on the 11th? Members on the opposition benches in this house felt that this was a step too far. All of these things happening. The member for number 7 has made the point. When we came to this parliament, there were gunmen on the roof with long guns. There were barbed wire on the streets. You could not drive down here. Go out in the street now, it's like if free traffic. But you could not drive down Church Street when Parliament was in. They had army man all over the place and gun on top of the house, up here on this the house. That was the environment in which we were in.
And in the back of the Parliament.
This was the environment in which we were in. And it's against this backdrop that on the 11th of December, the leader of the opposition then, the member for number 9, came and placed with the clerk a motion of no confidence in the then government, in the then Prime Minister and government of the day. 11th of December 2012. That was the environment in which we were operating at the time. And basically, we had a whole state of instability in our country. This was after 20 years, 4 terms of one person in charge. And it's out of this that you then found that 3 parties in our country who were not aligned with the government of the day came together as a government of a movement for national unity, a movement of national unity. It didn't end there, Madam Deputy Speaker, because having put off the budget, having not been able to deal with these very tremendous issues in our country, in the middle of January 2013, we had this debacle of an introduction of a senator's bill. We already had 2 members on the government benches and 1 opposition senator. And lo and behold, an individual walks off the street to sit on the government benches to vote for a bill. Huh? Jason Hamilton, you came in and sit down here and vote. Vote on a bill. Huh? That was what was happening. Huh? You know what I mean? Let's not forget, that senator's bill is a horrendous thing because you know what it was intended to do? I have the bill here. I have the draft bill. Huh? Know what that bill was for, That bill was intended, Madam Deputy Speaker, to increase the number of seats by nomination in this Parliament. It was intended for the Governor General to be able to get a nomination from the leader of the opposition, I think it was 1, and a leader of the Prime Minister. That is exactly what happened. The Senator's bill 2013, Madam Deputy Speaker, was passed into law, mark you, only within a couple of weeks to be struck down by the court. It went to court, and it's important to understand who took it to court. That bill was taken to court by the Honorable Sam Conduct and the Honorable Sean Richards. I have it here. Senators Increase of Numbers Act 2013. This is an act to give effect to the provisions of Section 26(2) of the Constitution by increasing the number of senators. And it goes on, whereas Section 26(2) of the Constitution, West Indies Act including the Constitution Court's orders, Cap 1.01, provides that the number of senators shall be 3 or such greater number, not exceeding 2/3 of the number of representatives as may be prescribed by Parliament, provided at any time when a person who is a senator holds the office of Attorney General, the number of senators shall be increased by 1. And whereas the number of senators has been the same as provided for by the Constitution since its coming into effect, and whereas Parliament now decides that a law be enacted in accordance with the provisions of Section 26(2) of the Constitution, so as to increase the number of senators from 3 to 6. In other words, this bill intended to change the Constitution, but it didn't come as a constitutional amendment. Not like what we're doing today. It came as a simple bill to increase the number of nominated members of this Honorable House from 3 to 6 members. And I don't have to go into the reason why, because there are people in this country who remember that there was a fracture in the Labour Party government of the day. And in order to keep functioning rather than adhere to the motion of no confidence that had been put before the Speaker, the Clerk and Speaker, and call an election, the then government determined that they're going to find a ruse to continue to function by increasing the number of senators. Not elected representatives, but the number of senators to stay in power. And they did so for 26 months as a result. And 26 in the schedule. So in other words, that there requires not just a 2/3 majority in here, but a 2/3 referendum, majority in a referendum in St. Kitts, and a 2/3 referendum in Nevis. That is what this bill had required. A man come off the street, vote in it, pass it into law. No referendum, no 2/3 of the elected representatives. That is what happened. Senators Increase in Numbers Act 2013. They struck it down. They struck down the fact that the appointment of the then member was null, void, and of no effect. And everything fell away as a result of that. They never did bring back the bill, because by that time they'd heard that they needed a constitutional amendment. And there was no attempt to do so. And not just a constitutional amendment, by a simple 2/3 majority of elected representatives, but you got to go to a referendum. And a referendum is like an election, which they don't think should happen.
Oh, it's in the schedule.
You know, it's in the schedule. We don't have to explain it differently, but that's by.
It was corrected. We went back to Parliament.
No, I remember you corrected the same day that Justice Benjamin put on his delivered his judgment. And what was happened is that he was null and void. The Attorney General resigned, and this individual was then appointed to that post, and then the Attorney General became back. That's how it was. That's how it should have been done first.
It was corrected.
But he was struck down. But you cannot increase the number of senators that way. That is the point.
That's respect for the rule of law.
That's,
We do the same thing.
you did not do it because, anyway,
Disrespectful.
Madam Speaker, Madam Deputy Speaker, I go on. Because this is the environment in which this country was. For 26 months, 26 months, this was the instability in our country. Instability. Things were rocky. And we say, as a result of that, that we wanted to go to our manifesto. And the honorable mover of the bill, Honorable Prime Minister, member for number 7, has made the point that on page 42 of the manifesto of the Team Unity movement, at letter E states this, that they would introduce legislation limiting the term of any one individual serving as Prime Minister to 2 terms. It was this whole desire for power, unfettered power, power in which, instead of calling a simple motion of no confidence to the floor and following the rule of law, that if it is, it fails, you call an election within 3 days. Let's go to election. And there was this delay. And as though that was not enough, we had the boundaries debacle. That I remember most vividly. Most vividly. Madam Deputy Speaker, this is what Team Unity was faced with. This is why we were created. To end this and to usher in a period of transformation in our country. And we have done well. We have done excellently in terms of our transformation. Those basic tenets are what we have stood for, Madam Deputy Speaker. The boundaries debacle I don't have to go into. Whereas the member for Nevis 10 and I were members of the Boundaries Commission, and we met upstairs on 1 floor up, one afternoon at 3:30, when the commission ended its work. And by 3:45, a parliament was being organized. We were only served with notice for parliament at 4:05 for a meeting of the parliament at 4:15. Imagine that. Normally we have to notify members by 7 days. 7 days. There could be an emergency sitting, but not 5 minutes. And there are members of this parliament on the opposition benches who were not served. You never get no service?
No, and I was here.
That is what we are faced with. So what we are doing, Madam Deputy Speaker, is to put a framework in place where we do not have an over-exuberance of power, that democracy is held in bay, at bay, in front of all of us, and we work towards that. As I close, Madam Deputy Speaker, because I see my time is soon up, I want to make the point, Madam Deputy Speaker, that what we are doing here is not novel in the English-speaking Caribbean. In the Commonwealth Caribbean, we have learned that in Guyana, the president is subject to term limits. In Belize, the Prime Minister is also subject to term limits. And I want to read into the record, Madam Deputy Speaker, this act of Belize, number 13 of 2008, which speaks to a similar provision in their constitution. In section 3 of this act, it says, Section 37 of the Constitution is hereby amended in subsection 2 thereof by adding the following proviso thereto. Provided that no person shall be appointed as a Prime Minister who has previously held the office of the Prime Minister for 3 parliamentary terms, either consecutively or in the aggregate. And for this purpose, the expression parliamentary term shall mean the period commencing on the date of the first sitting of the National Assembly after a general election and expiring at the date of the next ensuing dissolution of the National Assembly. And I want to commend to the House that this particular section of the Belize Constitution is at all fours with the bill that is now before this House. It's identical to the bill that is before this House, except we say, instead of 3 terms, that we now have 2 terms in our new constitution if this bill is successful. Madam Speaker, clearly, this amendment is not for the personal gain of anyone, but rather for strengthening our democratic institutions and the democratic process. It is for future generations who come after us. And it calls on all of us who are leaders in this country, in this House, to act accordingly and support this bill. Madam Deputy Speaker, I believe that tabling and enacting such legislation is a progressive move. I anticipate it would bolster our democracy and the rule of law in our country. Madam Deputy Speaker, this bill is about our future as we continue to grow from strength to strength as a sovereign, resilient, democratic nation. Madam Speaker, I commend this bill to this National Assembly and I ask for a safe passage in this House. May it please you, Madam Deputy Speaker.